Good morning. So I have a number of matters. I'm going to just run through the calendar and see who all's here. Um, and then we'll figure out where we're going from there. Um, First position, J.G. Wentworth versus Tasia Dozier. I know Mr. Counsel for Wentworth, so they thought they might be late. Are they here yet?
Judge, there's a box that says appearing shortly, John Rogers. That's Mr. Rogers, the counsel for this case. So my guess is when that box opens up with the video, he'll have returned.
Okay. Next position, Duncan and Seguin, I'm sorry if I mispronounced that, versus Micron Construction, Gregory Chandler, and Chandler Custom Contracting.
Scott Bushnell for the plaintiffs, and we've had all kinds of stuff happen since.
I know I've seen at least one motion to set aside, I think as to Micron. I don't know that I've seen anything regarding the two Chandler defendants,
But Mr. Chandler is now on the Zoom.
Okay.
So here's the thing. I haven't, counsel sent me this thing. I just saw it this morning.
Mhm.
I haven't even had a chance to look at the law to see whether or not it's valid or what the positions are on it. So I would take the position that I have no problem with the court continuing this hearing to allow me time to respond to that motion.
Okay. Do I have counsel here for Micron? Sorry, ma'am, you're muted, I think. It wouldn't be a Zoom hearing.
Sorry. Yeah, I'm sorry. I got the video on and not the mute. Yes, Gina Lindy Kugel on behalf of Micron. And, I apologize for the late filing. I just learned of this yesterday from my client. And it's, based on 91155B, which is the court's discretion. We've laid out some basic facts and we just request that the default against Micron be opened and we can proceed.
Okay. What are your thoughts on Mr. Bushnell's request, though, that there be that we briefly move this hearing that would potentially, if I have anyone here on behalf of Mr. Chandler, or I assume Mr. Chandler is also the principal of the Chandler construction defendant, that could also address that issue, because it would have the effect of we would need to move this matter to discuss whether Micron remains in default and a default judgment is fully entered, and then whether Chandler and Chandler Construction are found in default. Mr. Bushnell, do we have anybody on behalf of Mr. Chandler that you know of?
No, but
Okay.
Mr. Chandler is on the Zoom.
Yeah, I see him. Mr. Chandler, can you unmute so I can hear you, sir?
So
there you go. How's that? Can you hear me?
It's much better. Thank you, Mr. Chandler. So a couple of things I want to let you know, Mr. Chandler. Do you have an attorney? Do you have an attorney to represent you or to represent I assume you're the principal of Chandler Construction?
Yes, I am.
Okay. And do you have an attorney to represent you in either of those, either you or the company?
Micron, attorney.
So, Ms. Linda Kugel, are you going to be representing, to your knowledge yet, Mr. Chandler or Chandler Construction?
We haven't had that conversation, but that's a possibility, Your Honor.
Okay. Well, that sounds to me like an excellent set of circumstances that means this matter should be reset for another day. And it sounds like Mr. Bushnell, who might be in a different position to say, no, I want to have my hearing today, is agreeable to allow that to move forward. So
I just, given where things sit, I would just feel more comfortable having time to respond to the motion.
I understand, and I don't blame you. The only thing I do want to let you, Mr. Chandler, know is that in Superior Court, a company, an incorporated company or an LLC company can't represent itself through a person, right? It has to have a lawyer represent itself. So I just want to make sure you're aware of that as you determine how and whether you're going to be able to secure counsel for you and your company. Okay, sir?
Okay.
Okay. I will renotice this matter. It will probably be renoticed fairly quickly. I mean, not not tomorrow or the next day, but it will be, it will be reset maybe in the next couple of weeks, and we'll sort it all out at that point. Yes, Mr. Freehoff?
Yes, Judge, our next civil calendar would be October 10th, so the parties should probably prepare for an October 10th reset.
Yeah, let me check my calendar because I have a very busy October. I just want to make sure that we're all squared away. What time would that one be? I do have 2 hearings on that date already, but
Yeah,
there's
my calendars are always at 9, if it's for the general stuff like this, but if there's an issue, we might be able to specially set one at, in the afternoon, if that can work better for everybody.
I have in-person hearings that day in Gwinnett in the morning and DeKalb in the afternoon. So
Okay. Well, I'll tell you what we'll do, Mr. Bushnell, is we'll go ahead and notice the hearing for Zoom. And then if there is a way that we can work around your schedule, let us know and we will. If there's not, let us, let us know you have a conflict, which you've already indicated, and we'll
Right.
figure it out from there. Okay.
I appreciate it, Your Honor. Thank you. May we
Thank
be?
Thank
you.
you, Your Honor.
Yes, you may be excused. Thank you.
Thank
Thank you.
you.
Y'all hang on just 1 second, please.
Did she mean us?
I don't think so, but I'm not leaving until.
I
Wasn't
don't
sure that
believe she was referring to you specifically. I think she simply had to address something happening
Yeah.
off camera. So
Okay. If you need us, call us.
I will. Okay.
All right.
All
Thank
right.
you.
Thank you.
Bye-bye.
You can hang up. Okay. Mr. Rogers, I see that you've rejoined us. I'm actually just calling the calendar. So if you'll wait a minute, and I'll circle back and start with you once I get to the end of the calendar. Okay.
Thank you, Judge.
Thank you. Can't Sink versus Lifestyle Realty Company.
Good morning, Your Honor. Jacqueline Pylan for Can't Sink LLC.
Anyone here on behalf of the Realty Company?
I don't think so.
Okay. Next up is Dodson Woods versus Kristen and Alan Bailey.
Good morning, Your Honor. We are present.
Is anyone here on behalf of Dodson Woods Homeowners Association? Okay. Next up is Bedford Estates Community Association versus Sanisha Lawson.
Good morning, Your Honor. Frank Buddy here on behalf of Bedford Estates.
Good morning. Sanisha Lawson is available.
Okay, thank you. And Crystal Adams versus Crystal Enterprises.
Good morning, Your Honor. Attorney Sammy Carson here from Miss Adams.
Do I have anyone here on behalf of the defendant? Okay. And last but not least is Stave Company LLC versus Unknown Heirs of Walter James et al. Mr. Caskey, I think I saw a consent order come through.
Yes, Your Honor, but there was one answer filed by Mr. Dennis Paris. I do not see Mr. Paris on the Zoom, but assuming Mr. Paris is not here, I believe that we're in a position to wrap up the case.
Okay.
And I made sure that he got notice of the hearing.
Okay. So here is, for those of you, so so Mr. Rogers' matter, we're going to be able to take care of, and without question. And probably the matter regarding Tanisha Lawson, since both parties are here. But for those matters where one of the parties is not here, I think that Mr. Bailey, the plaintiff who sued you, is not here. Bedford Estate, no, that one is here. And then Crystal Adams and Dennis Paris. So here's what I am. So today, because even though this hearing was noticed as a Zoom hearing and was set as a Zoom hearing and has always been a Zoom hearing, the courthouse is closed today by emergency declaration due to inclement weather. And my understanding is the effect of that is that it extends deadlines. It has the operation of extending the deadline by which someone can comply with a court order. Now, there's no case law that or guidance by rule from the Supreme Court that says that a hearing that was always noticed by Zoom would not be affected by a courthouse declaration that would otherwise affect hearings and deadlines. And so I have concerns about entering defaults where one party or the other is not here, given that the courthouse is closed. Mr. Caskey, what is the nature, understanding that one individual is not present, what is the nature of that claim, if it were valid, that it is superior to any of the parties with whom you have entered a consent order, or would it be to the remainder if there is one?
Your Honor, this is a quiet title action, and
Okay.
one of those situations where we're left to search through obituary records and things of that
Yep.
nature.
I understand.
And
I don't relish it, but it may be that what I have to do is renotice some of these matters to another day. I can renotice it as soon as possible, but I am concerned, particularly in a quiet title matter, with a declaration where a party could come back and say, but that was entered on a day when the courthouse was closed. And by Georgia law, right, deadlines are extended when the courthouse is closed. I know it doesn't make any sense since this was always set as a Zoom hearing, and that person is free to be here. But I think in an abundance of caution, I have to do that. What I'm going to do is figure out when and how I might be able to reset this matter for next week to get a notice turned around as quickly as possible. It would again be at 9 a.m. And see if we can get these matters reset so that we can get them taken care of. And I'm going to go through them again and make that announcement. And anyone is welcome to stay here until the conclusion of the hearing substantively, in case any of the parties who aren't here are able to appear. Mr. Caskey, I know it's frustrating, but I do think that going forward.
One week doesn't change the world. So
okay.
Well,
so that's what I'm going to do. I'll get a notice out to you as soon as I can. But we will get something reset for next week. Probably towards the end of the week, because I think we typically try to do 5 days. But anyway, we'll get something done. It'll be a Zoom notice just like this one, and hopefully the courthouse won't be closed. So Mr. Caskey, you can be excused unless you want to hang around and see if that one gentleman, I think you said his name was Mr. Dennis, appears, or you're free to be excused. I'm not going to go forward even if he were to jump on.
I will certainly keep an eye on my email, Your Honor, but if it's okay, I will jump off.
Yep, I certainly understand. Thank you, Mr. Adams.
Yeah.
Is anyone here on behalf of Lifestyle Realty Company? So, Ms. Pyland, I'm sorry, did I?
Highland. It looks fancier than it is.
So the same thing would apply to your situation as well. because my concern would be that if I enter what I think would be a perfectly appropriate default, because this was properly noticed as a Zoom hearing, that ultimately it would end up being challenged and could potentially not stand as a result of the fact that the courthouse is closed today by emergency declaration due to inclement weather, and that has a real effect on deadlines. So for that reason, I'm going to put you on that same calendar. The idea is whatever can't happen today, I'm going to get it reset for maybe Thursday of next week. And it will, again, we'll be at 9 a.m., but we'll do what we can to see about getting it set. Okay.
Completely understand it, and I appreciate it, Your Honor.
Okay. Thank you.
Thank you. Have a great day.
You too. And do I have anyone here on behalf of Dodson Woods Homeowners Association?
Judge, I've sent an urgent email to petitioner's counsel asking them to appear. I've checked the pleadings. I don't see where attorney's fees were requested on a statutory formula basis. So until they can confirm that, I think
Did they open the notice?
Well, they've certainly sent us the motion for default judgment and the proposed order. So they seem to be aware of but I'll check to confirm that. But I think the fact that they did that suggests they did see the notice, but I'll check.
And that's the one that Mr. Bailey, that you're here on. Is that right, sir?
Yes, ma'am.
Okay. If you'll just continue to wait for a moment, we're going to see what's going on with counsel and then see what we can declare. But again, I'm afraid your matter will fall into that same bucket, that if the courthouse is technically closed, I may not be able to take any action today regarding this hearing, and then it would need to be reset for that next week calendar that you've heard me mention. But if you'll sit tight for a few minutes, we'll see if we hear from counsel, okay?
All right. Yes, ma'am.
Thank you, sir. And then Crystal Adams.
Yes, Your Honor.
Mr. Carson, I don't think I heard anyone on behalf of Crystal Enterprises or Ace LLC. Okay. And so Mr. Carson, that would fall into the same bucket. If you want to go ahead and be excused, I'm going to renotice the hearing for next week for a day when the courthouse isn't closed. And and we will see if they appear at that time. Okay.
All right. Sounds good. Thank you, Your Honor.
Thank you, sir. Yes, sir. Have a good day.
All right. You too.
And then so I know I have both parties in the Bedford Estates versus Sanisha Lawson. And so what I'm going to do is take a brief moment, Mr. Rogers, and let you go ahead and go. And then I'll take another head count and figure out what we're doing. Mr. Rogers is your client. I see Tasia Dozier. Am I pronouncing that correctly? Ms. Dozier?
Yes.
Okay. Did I pronounce your name correctly?
Yes, you did.
Okay, thank you. So Ms. Dozier, if you could please turn your video on if you're able so that I can see you. And then Mr. Rogers, if you want to go ahead with your presentation, sir.
Thank you, Your Honor. Ms. Dozier, can you raise your right hand, please? You swear that the testimony you will give before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Tasia Dozier.
And Ms. Dozier, you can put your hand down.
Okay.
Do you live in Fulton County?
Yes.
Are you married?
No.
Do you have any children?
No.
Did you enter a contract with J.G. Wentworth to transfer a $30,000 payment that comes due on March 14, 2027?
Wait, say it again.
I'm sorry, I may have some bad information. Bear with me just a second, Ms. Dozier. And Judge, I may have given you some bad information in my summary sheet. I
tell you what, I think I've seen an attorney jump on. Do you want me to give you a moment to collect and figure out where you're going and then come back to you?
I should be ready in just 2 seconds, but
okay.
I don't want to inconvenience the court. Obviously, I just need to pull up something and I've got it right now.
Okay, then go ahead.
Pardon me, Judge. Ms. Dozier, did you enter a contract with J.G. Wentworth to transfer a payment of $26,010 that comes due on November 26th of 2031?
Yes, sir.
And do you understand that today that payment is worth about $17,997.99?
Yes.
And you've agreed by contract to receive a lump sum payment of $6,500. Is that correct?
Yes, correct. I do want to ask a question. Is it correct that I will have 3,500 left over in my account at the age 31?
And unfortunately, Ms. Dozier, I don't know the answer to that question.
Okay. That's what I was told, so I'm just trying to see if that's true or.
Yeah, and I don't have access to that information and wouldn't have any way of knowing. And I'm sorry I can't answer that question. Do you understand that that amounts to an effective interest rate of about 21.03% per year?
Yes.
Ms. Dozier, did you get the copy of the petition and the hearing notice over 20 days ago?
You said a copy of what?
The petition and the hearing notice. Did you get that over 20 days ago?
Yes.
Did you have a chance to speak with a lawyer or a financial advisor, and did you waive that right in writing?
Did I speak to who?
Did you have a chance to speak with a lawyer or a financial advisor, and did you waive that right in writing?
Like a notary?
Oh, let me ask this. Do you want to talk to a lawyer or a financial advisor before you go through with this?
Will they be able to confirm if I will have a remainder left in my account?
I don't know the answer to that question.
I'll tell you, Mr. Rogers, I think you might need to take a break because it sounds like that's something that she wants the answer to. And it's a substantial enough issue that she's asked about it twice now.
Okay.
I think we need to have an answer for her for me to find that she has knowingly and intelligently entered into this contract. If that's something you can find in a few minutes, then we can just take a break and you can get that information. If it's not, you can jump onto that calendar for next week that seems to be popping up.
Okay, I will stay logged into the meeting if I may, and I'll see if I can find out that information.
Okay. Ms. Dozier, I don't know if you heard that, but Mr. Rogers is going to see if he can get that information for you about
Okay,
that
can I
$3,500.
say something as well? Because I was talking to Patrick and Matthew under JG Wentworth, and they did tell me that I will have that remaining balance. But I just wanted to hear from you guys that that's true.
No, I understand that, Ms. Dozier, and Mr. Rogers is just going to try and confirm that for you because
Okay.
As I'm sure JG Wentworth told you, the purpose of this hearing is to satisfy the court that you understand what you're doing and that it's
Right.
intentional. And so I think it's important to make sure that you and me both have a clear answer to what funds you might have left over in that account. But if you'll just stay, you can mute and you can turn off your video for right now. But if you'll just stay connected to the hearing, we'll let you know when it's time to jump back on. Okay.
All right. Thank you so much.
Thank you, ma'am. Okay. So that takes me to, do I have anyone here on behalf? Well, let me ask the easier way. Ms. Horlock, I see that you have recently joined us. Can you tell me who you're here on behalf of?
Sorry. Yeah, good morning. I'm here on behalf of Dodson Woods Homeowners Association versus Bailey. And I think Mr. Bailey, I see him.
Yes. Mr. Bailey is here and has been here since the calendar began this morning at 9 o'clock.
Are you ready to proceed?
Well, now that I have lawyers on both sides, or well, that I have parties, I guess, on both sides, yes. I'm actually going to jump over to another party that was here before you guys were. I just wanted to make sure. I thought that's what you were here for, but I wanted to make sure, Ms. Warlock. You'll give me just a few minutes. Okay. So the Bedford Estates Community Association versus Sanisha Lawson. I see that I have Ms. Lawson.
Yes, I'm here.
Okay. And Mr.
Buddy, Your Honor.
Is it Butta? I don't know how to pronounce your last name.
Buddy, Your Honor. Just
Buddy.
like
Oh, that's so much
line.
easier.
Yes.
Okay. So, Mr. Buddy, this was set on the calendar as a default. I will note, you probably saw it as well, that I don't know the dollar amount that was owed, but I was, this morning it came across that a receipt that Ms. Lawson had provided for payment of some amount. I don't know if it was
Yes.
the full judgment amount or not.
We've received it. Our position is it's not the full judgment amount, but I can break it down for the court.
Okay. Well, why don't you go ahead and present because we are technically here on a default. So why don't you go ahead and present, and then I'll hear from Ms. Lawson about that payment.
Yes, Your Honor. We filed this lawsuit on August the 2nd of 2024. It's been more than 45 days without an answer, and we filed our motion for default judgment. We are seeking principal in the amount of $1,910, interest in the amount of $127.79, attorney's fees in the amount of $1,501.50, and I'll provide testimony on that, and court costs and expenses in the amount of $394.09. And as the court indicated, Ms. Lawson did make a payment process on September 12 in the amount of $2,417.80. And that leaves us with a total balance owed of $1,515.58. Regarding the attorney's fees, I can testify that I'm an attorney licensed to practice law in the state of Georgia in good standing. I've been an attorney for 15 years. I'm associated with the law firm Coulter and Sierra. For the past 2 years, my work has been exclusively devoted to the community association area, and I'm familiar with the typical hourly rates in this area. The hourly rate that we charge to the Bedford Estates Community Association is $275 an hour, and the paralegals in our firm bill at a rate of $135 an hour. Myself and the other attorneys in the firm supervise, oversee, and manage all the work done by the paralegals. In this case, the association has incurred a total of $1,501.50 in attorney's fees and $394.09 in court costs and expenses through the date of today's trial. I've reviewed the attorney's fee statements, and the amounts charged in terms of the hourly rates and the total hours are reasonable in light of the work done and are customary for the community association practice in Atlanta. And so we'd ask the court to enter default judgment in the amount of $1,515.58.
Okay. Question, Mr. Buddy, is
Yes.
the attorney's fees that are sought pursuant to the declaration, are those 13,111? Are they just straight up contract attorney's fees?
Our position is both, but we would typically argue it's straight up contract attorney's fees based on the assessment provision in the declaration.
Okay, thank you. Ms. Lawson, I did just let you know, I think you heard me say that a moment ago. I did receive an email this morning indicating that you had made a payment, which Mr. Buddy indicated that had been received and credited for that $2,417.80. But this would be your opportunity to respond if you would, whatever you would like me to know about the damages that they're asserting that they're entitled to.
Yes. Good morning, everyone. I actually did pay. I paid on the 2nd of September, not the 12th. And I was under the impression that per the letter that was sent to me, that was the amount due of the $2,417.80. It says your charges are not for fees. It said for like the fees and attorney fees are included in that. But however, maybe I misunderstood that and only thought that it was the $2,417.80. So I in turn paid that. If there is any additional fees, I can't fight that. I didn't know, honestly, and if it is required for me to pay, I don't have a problem with paying.
Okay. Are you in a position to pay that now?
No, not today at this moment. Okay. As you can see in the email, I just traveled back from Arizona in regards to trying to gain custody of my grandson, which was in a situation. So I have spent a lot of money within a few days, within 4 days. So if they can give me a short time to get it resolved, I can assure them. But again, I was under the impression that all the fees was in that $2,417 as noted on this document.
Mr. Buddy, can you just confirm for me that you're familiar with the letter that would have been sent to her, and that it sounds like she's a little bit confused about whether that letter says this is the amount you owe, not counting attorney's fees that might be incurred, or that I haven't seen the letter, so I don't know.
And I believe what she's referencing is attached to our complaint as Exhibit E. It's a letter dated May 28th of 2024, and it does have the total amount due as of that date to be this figure of $2,417.80, which is what she paid this month. But the letter goes on to explain that this amount's good for 30 days, and if it's paid within that 30 days, we won't file suit or incur any additional fees. What happened in the meantime is we didn't get that payment within 30 days of the letter, and then we incurred some additional expenses to file the complaint and to get process served. And so we incurred another $491.50 in attorney's fees to do that, as well as some court costs. Then there was $46 to process the payment, which she made early in September. And then in the attorney's fees, we included another $578 to prepare the default, to prepare for the hearing, and then to attend the hearing today.
Okay. Well, and thank you for being able to direct me to that letter, because that helps me understand what would have been communicated to Ms. Lawson in terms of the timing and what her obligation was. So the purpose of today's hearing is that this matter was served on Ms. Lawson on August the 5th. That means that her answer, by my calculation, was due on September the 4th. No answer was filed, and 15 days passed without an answer being filed or the default being opened as a matter of right. And Ms. Lawson could have opened, by my calculation, default by September the 19th. Yes, Ms. Lawson, did you want to say something?
I actually did. I did that on the September 30th. I've called into you guys' office and got like some guidance in doing that on the computer, answering on the computer. And we did go through that. So I did do that. And they also stated that, you know, that it should have been resolved, and I really didn't have to do it, but I still went through the process of answering too as well online. So I'm not sure what they were stating that I didn't, but I did. That was on the 3rd of September.
Okay, so if you have some documentation indicating that you attempted to file something on the 3rd of September, then you would need to provide that to the court. You'd need to file it. I'm looking at my docket, and my docket indicates that this case was filed on August the 2nd, and that an affidavit of service was filed on August the 7th, indicating that you were served on August the 5th. And then the next thing that was entered was by the court in September on the 18th. And there's no record of an effort to file anything on the 3rd. Again, if that is something that you want the court to consider, then you can file it. But for now, the record indicates, the docket that I have available to me and the information that I have available to me indicates that no answer was filed by the due date, and that more than 15 days has passed since that date, since you became in default, and that no effort to open default as a matter of right, which would include the payment of costs and the filing of an answer, has been made. And so it does appear to me, Ms. Lawson, that Ms. Lawson is in default. But for the credit that she received for the payment that she made in early September. And so the judgment amount will only be that $1,515.58 that was requested by Mr. Buddy, which would be the total amount owed plus fees, costs, et cetera, including fees, costs, et cetera, minus the credit for that $2,417.80 payment. Is that correct, Mr. Buddy?
That's correct, Your Honor.
Okay. I don't know if the proposed order that you have submitted, or if you have submitted one by email in Word format, but if you have or have not, if it does or does not include, can you please send one that includes the credit and the correct amount that you're seeking the judgment for?
I believe we did send one, Your Honor, that does include the credit, but I will double check on that if we have not, make sure.
I have no reason to question. If you think you sent it over, you probably did. I haven't had a chance to look at the proposed orders. But Ms. Lawson, as I said, if you want to file something regarding that issue, you're free to do so. I can't give you any legal advice. But as for today, it does appear that there is that you are in default on this matter for that amount of the $1,515.58. And so I'm going to enter that judgment, And then you
Who should I
can,
provide those paperwork? Oh, okay, you was getting ready to say.
no,
Because I
that's
think I
okay.
took some screenshots of, me.
Right. And like I said, you can file that if you choose. The court will
Okay.
consider it if it's filed.
Okay.
You can also reach out to Mr. Buddy or the association regarding payment arrangements for the
Okay.
judgment amount. Okay.
Okay.
Thank you,
Their
ma'am.
number for them, just call the Coulter and Sierra or
Mr. Buddy,
Yeah.
is there a
Yes.
number that Ms. Lawson could reach out to?
I can give her the number, yes.
Thank you.
Ms. Lawson, just let me know whenever you're ready.
I'm ready.
It is 404 554 2071.
Okay. And then that amount was $1,558 and
That's
1,515
1,515 and 58. So 1515 and 58
okay.
cents.
58. Okay.
Thank you.
Thank you guys.
Have a good day.
You too.
Thank you, Your Honor.
Bye-bye.
Okay, and then I have Mr. Rogers. Were you able to get the information that I was asking for?
Yes. The short answer is that I have confirmed that there's $35,000 left on the annuity. That's what my client told me. And Judge, I'm looking at a letter dated May 31, 2024 from New York Life Insurance Company that says that the benefits payable are a $25,000 payment in 2026 and then a $61,010 that comes due in 2031. That $25,000 payment was transferred by Ms. Dozier in an earlier transfer.
Like in June?
Yes, that's correct. And so if she transferred $26,010 today, there should be $35,000 left on that annuity.
Okay, that's all I was just trying to confirm. I just need to hear from y'all.
Okay, thank you. I appreciate that, Mr. Rogers. You can continue if you'd like.
Okay, and just to be clear, I don't have personal knowledge of these things, but if the documents say what they say, mean what they mean, I assume there should be, in fact, be 35,000 left in the tank.
I understand. I'm satisfied with that answer. I just wanted to make sure we had an answer that we could be satisfied with.
Okay.
Do you guys know how soon it will hit my account?
I don't, but right now we've got to get through this process and because I've got to sign off on the paperwork before anybody can initiate that transaction. I suspect though that once this process is handled, that the people that you're working with at JG Wentworth would be able to give you that answer.
Okay, because they told me that you would have to sign the court thing first.
That's correct. That's correct.
Okay.
Mr. Rogers, I interrupted you during your presentation because I wanted an answer to that remainder issue. So if you want to pick up where you left off.
Thank you, Your Honor. Ms. Dozier, do you want to speak to a lawyer or a financial advisor before you make this decision?
No, it's fine.
Okay. Would you like to go through this transfer? Are you asking the judge to approve it?
Yes.
Tell the judge what you wish to do with the funds if she approves the transfer.
Okay, well, basically, I am trying to purchase my vehicle, really, hopefully before Monday. I do start my global life agency job Monday. And also I'm hoping, I do look forward to getting my apartment soon as well. So that's really what I'm trying to do with that money. Just get back on track.
Okay.
Your Honor, I have no further questions.
Okay. Thank you. Ms. Dozier, as we were discussing, the reason for hearings like this, and it sounds like you may have been, you've probably been through one of these hearings before, if you've done this before, is for the court to be satisfied that you understand that what you're doing, right? Because obviously, I know 2026 is a long way away, or 2031 is a long way away. But obviously you understand you're getting a lot less money now than you would be entitled to if you waited until 2031, right?
Right, correct. I know.
Okay. But it sounds to me like Ms. Dozier has had an opportunity to speak to an attorney or a financial advisor that she doesn't feel she needs to, that she's familiar with this process and she understands the reduced value of the funds that she's receiving now versus in the future. And so for that reason, I will go ahead and approve the application for that reduction. I believe you've already sent over a proposed order. Is that right, Mr. Rogers?
I have not. I'm waiting to get a copy of the order signed by Ms. Dozier from my client. As soon as I
Okay.
have that, I'll forward it to Chambers.
Okay.
Is
So
it
Ms.
something
Dozier,
in my email that I need to go check?
I don't know how they would have sent it. I would presume it would have gone to email, but I just don't know.
Hold on, let me see.
so we don't need to be on the call for you to check that, but I do, Ms. Dozier, just to make sure you understand that what typically will happen is that Mr. Rogers will have signed on behalf of JG Wentworth, and then you will sign, and it will come to me, and then I will say that I approve this agreement. And so you should look in your email, locate it, and then make sure to send it back to whoever sent it to you, signed. They'll send it to me, and as soon as I have it, I'll get it on file for y'all. Okay?
Judge,
Okay.
the order just hit the wire literally a second ago, and I'll forward that to Chambers.
Okay, excellent. Okay. Well, it sounds like we have what we need, and we will sign and get that back to you as soon as we can.
Thank you so
Okay,
much.
so once it's
Thank-
signed, will it start processing, or you guys can't give me the answer?
I cannot. What I can tell you is that I'm going to have it filed, and we'll ask for it to be expedited. But once I sign the order, the order is signed, and then it's up to JG Wentworth how quickly they can act with respect to that.
Okay,
So-
thank you.
Okay. Thank you both.
May we be excused?
Yes, you may. Have a good
Thank
day.
you, Judge.
Okay, Ms. Horlock and Mr. Bailey, thank you both for your patience. So I have, this matter is Dodson Woods Homeowners Association versus Kristen Bailey and Alan Bailey. And I have Ms. Horlock on behalf of the Homeowners Association and Mr. Bailey here on his own behalf. And so this matter was set down for a default hearing today. The issue being that, let me make sure that I have my ducks in a row. So my file indicates that this matter was filed on July the 29th, and that service was made on both of the Baileys on August the 6th, which would mean that the answer would have been due on September the 5th, and default would have resulted on default would have been final, essentially, on September the 20th. And I don't have any record of an answer having been filed. And so we entered an order to file a motion for default judgment. The Homeowners Association complied with that by filing a motion for default judgment. And that's what we were here today to hear from Dodson regarding that matter, and to hear from Mr. Bailey regarding the assertion of damages on that issue. Ms. Horlock?
Yes, Your Honor. Those are the dates. That's the timeline that I have too. As you said, we have filed a motion for default. With that was an affidavit of Wayman Cumberlander. These are liquidated damages, and he verified the account ledger for the balance owed. Lisa First is the primary attorney who's been handling this case. She submitted an affidavit of attorney's fees. I am the managing partner of Pankey and Horlock. I review all billing records, and I actually send out the bills every month. We bill or Lisa bills at the rate of $300 an hour, as do I. She's been practicing since 1985. I've been practicing since 1991. Since 2008, I've been doing exclusively community association law. So Lisa and I both bill at the hourly rate of $300 an hour for this, for Dodson Woods. Our paralegals bill at the rate of $125 an hour. Attorneys keep their time as the time is accrued. It is entered into our billing system. The next day, it is reviewed at the end of the month before the association is billed. I have reviewed the attorney's fee statement that's attached to Lisa First's affidavit of attorney's fees, and that is a correct and accurate billing statement of our time and the expenses incurred. Lisa and the paralegals, our records show that Lisa and the paralegals spent 5.9 hours sending the demand letter, following up with the owner, drafting the lawsuit, following up with the owner again, drafting the motion for default. And that resulted in attorney's fees in the amount of $1,362.50. There are additional expenses in the amount of $74.93 and filing fees paid to the court in the amount of $313.61, resulting before this hearing in a total amount of attorney's fees and expenses in the amount of $1,751.04. We are asking for an additional 1 hour of my time for preparing for the hearing and attending the hearing. I believe we have submitted a proposed order, but the spreadsheet that we have submitted shows that the principal balance owed is $1,520. Interest accrued at 7% simple interest in the amount of $218.98. I have already given you the balance for attorney's fees, and I'm asking the court include an additional $300 for preparing and attending the hearing.
Okay, so there is a proposed final default judgment that was filed in the system, although we do ask that they be not filed and instead emailed to us in Word format. But it has a final number in it of $3,490.02. Is that the number that you have that includes your additional time for today's hearing?
Your Honor, that does not include the additional time for today's hearing. If you add $300 to that, it comes to $3,790.02, and I can submit a Word version of that as soon as we leave this hearing.
Okay, thank you. Mr. Bailey.
Good morning, Your Honor.
Good morning, sir. Go ahead, I'm sorry.
No, go ahead. I was just saying good morning. My apologies.
That's okay. So the reason I started with that sort of background that I gave in terms of the timing is to let you understand what is the purpose of today's hearing. So you have already, the time for you to file your answer, where you might have asserted defenses and said things about why you didn't owe the money or things like that, right? That time has passed because that time was no later than September the 5th. And then there's a procedural time during which you could have done it as late as September the 20th, but that didn't happen. And so what today's hearing really is an opportunity for you to talk to me if you do have an issue regarding the amount of the damages that are sought by the homeowners association. And so I just want to let you know, I will hear from you, but I always want to caution you that it's sort of a limited inquiry that the court is allowed to make. And even then, there's an argument that these are what we call liquidated damages, which means they're due and owing under the contract. But I wanted to give you an opportunity to say your piece and see what, let me know what you think I need to know before I enter any judgment or take any action.
Yes, ma'am. Thank you. So I appreciate your time. My wife is also here with me as well. She's just pregnant, so she's in the background. We're expecting this week. So
that's very exciting.
Yeah.
I hope the weather does not complicate any of that for y'all.
Yeah, that's what we're hoping. The doctor is like, you guys will be inside, but if it's that time, you guys got to figure out how to get here. So we're just praying that today is not that day, honestly, because of the weather. But yeah, so I honestly did not understand all the dates in its entirety of this situation, but hearing the situation as of now, I do. I will say, and I'm not sure if that even could hinder us or help us, but we honestly, the mail for what was mailed to us was actually getting mailed to our neighbors, and it legitimately just got over to us on Wednesday. So I was actually unable to respond to anything because I actually asked the attorney, but the attorney told me the same thing you just shared. Like I had to respond by a certain date, but we didn't receive that mail. But I'm not here to go back and forth on that. My honestly, we take complete ownership of not being late on our payment of the homeowners association. We were under the impression that when it changed, I think I was calling or emailing the wrong homeowners, because I think our homeowners association changed within the past year or 2 years. And transparently, like I said, we are looking to pay it, but the dollar amount that I think was mentioned, like $3,400, which I got to understand that is, I guess, with attorney fees and the judges this time, is just double of what we currently owe. And we honestly, at this current moment, I don't have the funding. And I know when I did talk to the office, they shared with me I could go into a payment plan, but I don't say I'm the brightest in the bunch, but I start adding numbers really quickly. And I was told that I could do a payment of like $235 in roughly $235 over a course of 28 months. And that came out to be a total of like $6,000 and some dollars. And they said that would cover the $1,500 that I owe to Dodson Woods for homeowners, and then the additional would be for the other 2 years. So it just was kind of hard for me to say I'm paying $6,500 over a course of 5 years of a payment plan, and only technically should have paid over a course of 5 years 500 times 5, which is $2,500. So I just was kind of, basically, if I don't have it now, it's kind of, I didn't want to put myself in a situation to where like, hey, I don't have it now, and I know if I pay a payment plan, even I might potentially set myself up not to be able to finish that payment. So I just wanted to see, I guess, the best way we could go. But I'm also looking for a new career at this current time. Mm-hmm. And as I mentioned, as you see in the background, we do have a current toddler and a newborn on the way. And I just had accident. I was hit by a drunk driver, so I don't have a car right now. So I'm trying to honestly put focus on making sure I can provide transportation for my family.
I'm so sorry.
I appreciate it. I just wanted to say I do take ownership. I'm not here to try to go back and forth. I just need to make sure it's something that's affordable that me and my family honestly could make sure that we could do.
I understand. And certainly I don't quite understand all the particulars of that, but generally my experience is that most homeowners pay either through their mortgage or they pay separately to their homeowners association a certain monthly assessment. And I'm assuming that the dollar amounts that you were given would be for what you actively currently owe. That's not a judgment amount, plus an additional amount to help you get current with that old amount. I don't know the answer to that question. And of course, you did correctly understand that, unfortunately, when I look at, when I look at a judgment that says you owe $1,520 in arrears in terms of old assessment that were due that did not get paid, and then of course the attorney's fees are nearly equal to that amount or greater in this instance. I understand that it can be frustrating and confusing to homeowners that find themselves in this very unfortunate situation. I have seen many of these, and Ms. Horlock is correct that $300 an hour is not an unreasonable. In fact, it's very reasonable in Atlanta, and 5 hours of work for this is not excessive. And so the amount of time that Ms. Horlock's firm has billed for filing the complaint and preparing for the hearing and appearing today, it's just not unreasonable. And so unfortunately, as I said, I understand that you've had, it sounds like a really bad run of bad luck. And for that, I'm so sorry. And I really hope that, this new life and this new baby is going to be a start of new and wonderful things for your family. Unfortunately, I have to put that final pin in maybe the end of that negative part for you, which is this. the file that I have, I understand you were having a run with not getting mail, but the file that I have is certified by a process server indicating that personal service was made where it was placed in the hand of you and Miss Bailey. And so those papers come with them, directives saying you have to file within 30 days and answer, and that didn't happen. And so legally, given the presentation that's been made, the paperwork that's been made, and more importantly, the contract that was signed, right, by you and Ms. Bailey, indicating that you understood your obligation to pay these assessments as part of your homeownership in that neighborhood.
Yes.
The court finds that Mr. and Mrs. Bailey are in default based on the dates that I outlined a moment ago, and that the amounts owed are the appropriate amounts to be entered as a final judgment as outlined by Ms. Horlock. Ms. Horlock, if you could please have someone send over a proposed order in Word format with the correct dollar amounts. We will get that on file. Mr. Bailey, I just encourage you to reach back out to the Homeowners Association and make sure that you have a clear understanding of what it is they're asking you to pay if you're going to do a monthly payment type arrangement, so that you can get current and again, start off much more positively with that brand new baby. Again, I'm sorry to be part of the negative for you, but I do wish for the best for you going forward, sir.
I appreciate it. I do have one last question. I know because
Yes, sir.
my wife, just because I want to put her at ease, because obviously we know that homeowners association, I guess if you're in default, could potentially take your home, and obviously her being 4 or 5 days pregnant, she's wanted to know like clarity on how, like when people say that, I guess Google that, what exactly does that mean? Homeowners association could take your home from you, essentially.
So I can't give you any legal advice, Mr. Bailey. What I can tell you is that, and Ms. Horlock, you jump in here if you have any concerns, but the order that's been submitted to me is simply for a judgment, a dollar amount judgment against your home. Sometimes I will separately receive proposed orders that include a foreclosure provision that says this amount has not been paid and therefore we are entitled to exercise our rights to foreclose on the home to recover our debt. That's not in the order that I'm being requested to file. And so again, I can't give you legal advice, but I can tell you that currently the order I'm signing does not authorize a foreclosure action, but that doesn't mean that the declaration to which you are a party, if those amounts continue to go unpaid, could not result in someone exercising. But again, I can't give anybody legal advice, but I think that the actions that are allowed to be taken by a homeowners association are supposed to be included in the declaration. I know it's very large, but it is something that you can access and maybe try and understand that there. Ms. Horlock, am I correct? Are you in agreement with me that the order you've submitted is an order simply for a default money judgment?
Yes, you're correct, Your Honor. And Mr. Bailey, the amounts that you owe constitute a lien against your house. And with the judgment, it will be a judgment lien, but the association isn't trying to take your house. So that's not part of it. And I understand how that would be a concern for you. Also, I don't have authority to enter into a payment plan right now, but if you'll reach out to my office today, if you have time, and actually you should reach out to Lisa first. And if you have already talked about a payment plan in the past, I'm sure something can be worked in the future. What you need to remember, though, is that as you make payments, if it's a long-term payment, like a 5-year payment, it's going to have to include that when the annual assessments for the years during that payment plan, when they come due, you have to pay those too, in addition to the past due amounts. That's probably why it looked like an excessive amount to you, but what it included was everything else that was going to come due during that time period. It didn't mean all of that was due right then, but it was an overall balance that if you pay this over however long, 5 years, you're going to have to pay the past due balance now in monthly payments plus the annual assessments as they come due each year. And that's why that dollar amount probably seems so large to you.
Right. Yes. Yeah. She stated, I think it was, they inquired that I guess Dodson Woods were right now it's $500 a year, and she stated that she's expected for it to go up to $750. So she
Right.
it to be 2 years of $750. So you're correct.
Right. So contact my office today, contact Miss First, and I'm pretty sure that we can reach some type of mutually agreeable resolution.
Thank you. Do you mind sharing? Because I'm sorry, that the best contact number. So I'm gonna call as soon as we get off of this call. If that's
yes. It's 770-670-6250.
All right. Thank you so much.
Thank you. And
Okay.
good luck to you, and Mr. and Mrs. Bailey. I'm very excited for you. I hope everything turns out wonderful and healthy. Okay.
All right. Thank you so much. I'm good to be.
Thank you.
Thank you, Your Honor.
Thank you. And thank you, Ms. Horlock, for jumping on the call. Have a good day, everyone.
All right. Bye-bye.
Your Honor, I apologize for being late. I thought the courthouse was closed. So.
And I had to address that issue because there were some default matters where both parties did not appear, and I had to kick them to another day.
Right.
Because of the fact that both parties were not present, because I have concerns, given that the courthouse is closed, even though this was a Zoom hearing and it was always noticed as a Zoom hearing,
right.
that someone could take the position that if deadlines are suspended when the courthouse is closed, as we all understand them to be,
Right.
what effect does that have? And of course, there's no case law, there's no guidance from the courts on how to deal with that in this new Zoom arena that we have.
Right.
So,
Right. All right.
Anyway, thank you
Your
again,
Honor.
Ms. Horlock. And the last person I have is Mr. Harris. Mr. Freehoff, do you recall, is that the name that Mr. Caskey mentioned?
I do not recall if that was the name Mr. Caskey mentioned. I don't.
Mr. Harris, can you tell me
Yes.
what you're here for?
Yes, Your Honor. Good morning. I received a notice from Headway Capital LLC about a Zoom meeting, Zoom hearing today. And I was waiting on the line. I received this information, but I see that when you called the calendar, it wasn't on the calendar. So I'm just kind of confused and trying to get some information as to how to proceed next.
I believe the reason for that is that, can you give me the case number, please?
Yes, sir. The case number will be 24 C as in Charlie, V as in Victor, 007873.
Yes. This is Headway Capital versus Slush Restaurant and Bar LLC, and as well as Damon, I think Damon Harris. Let me just confirm that. Yes. That judgment order was entered because, as your notice states, if attorney's fees are being sought and are not liquidated, and I may let the judge explain that to you, then there's a need for a hearing. But if they're liquidated, meaning there's a statutory formula by which they are derived, they are automatic and liquidated. And so the court entered that order, and the provision in your notice that says it may be possible, it may occur that there's no hearing needed, and as a result, this hearing may come off the calendar, is what in fact happened with this case.
Right. So Mr. Harris, so what Mr. Freehoff was explaining is, we sent out that notice, right, which you assume either received from us or received from Headway Capital. But in any event, there was an effort to secure a judgment against you related to this contract. And then we went ahead when a proposed order was submitted, and the damages were, we refer to them legally as liquidated, which is they're an established amount that I don't need to have a hearing to understand or to hear evidence or testimony about the amount. And so that paperwork was done and it was submitted to us, and that order was entered on what date, Mr. Freehoff?
Well, it was entered yesterday. The reason Mr. Harris may not have received it is if he's not a service contact in e-file Georgia, but it also hasn't been accepted by the clerk yet. So
Okay.
while it has been signed and submitted to the clerk has not accepted it, so it's not appearing in the record yet.
Mr. Harris, can I, one, do you have any questions? Two, if you would give us an email address, Mr. Freehoff could provide you with a copy of the document that we're referencing, so you would at least would know what we're talking about.
Yes, Your Honor. Yes, so I'm assuming that the default judgment was granted.
Yes, sir, that's correct. And the document that I'm referring to is that there was an order, that would be the final default judgment that was entered yesterday.
Wow. Sorry about that. Yeah, when I received the mail, which was yesterday, and I tried to get to the courthouse to file an answer, but once I read the notice, the documents that I received, it was saying that Thursday and that the answer had to be in 24 hours before the hearing, which was at 9 o'clock. So it was like 4 o'clock yesterday.
Right.
And,
So
I believe the notice says that it's
well, hang on. So I understand that the notice might say any number of things about what you might do to comply with the notice hearing by appearing or otherwise. But what matters here, Mr. Harris, and I understand that it is frustrating, but the record that I have from the court indicates that this matter was filed some time ago and was served on you personally. And that it was, hang on, I'm opening it now so I can give you the exact date. But the court record indicates that this matter was filed in June of 2024, and that you were served, my records indicate, August 8th affidavit was entered indicating that you were served on August the 3rd. And that means that your answer would have been due on, let's see, it would have been due on September the 3rd. Technically, it would have been due on the 2nd, but the 2nd was a holiday. And then that means that you would have had until no answer was filed by then. And so that means that you would have had until the 18th of September to do what we call, file a motion to open default or something like that. And that didn't happen. And so I understand that you might have only received a mailing from us about this hearing today a few days ago. But what was supposed to have happened in your case is when you were physically served, either individually or I think maybe as the representative of your company, that paperwork indicated to you that you had 30 days to file a response. And I don't have any record from the court that you filed any response. And so that meant that you became in default. And then there's a 15-day window where you can open default as a matter of right. But even then you have to file an answer and you have to pay court costs. And that didn't happen either. And so now you are in default, and that is why we went ahead and entered that default judgment. And so I understand how frustrating it might be that the mail is what the mail is. But the purpose of today's hearing, had it gone forward, was for me to hear from Headway and you regarding the amount of any damages that were liquidated. And what Headway said was there aren't any liquidated damages. These are known dollar amounts that are established by contract. And so we entered a judgment based on that. I can't give you legal advice. What I can tell you is two things. If you are the principal of the corporate entity that slush entity, I do want to make sure you understand that anything that you might want to do, that slush is a corporate entity, must have an attorney in my court. In superior court, corporate entities must have lawyers, right? They can't be represented by the person who is the principal unless you're also a lawyer. Now, you can represent yourself and you can take whatever action you deem is necessary. But today, or actually yesterday, the court entered that final judgment, and that was that was the final action that the court intends to take, unless the parties come to me and ask me to revisit that issue or to take some other action. Do you understand, Mr. Harris?
Yes, Your Honor. Yes, Your Honor. And thank you for that.
Thank you. Do you want us to send you a copy of that final judgment, or, I mean, you will probably receive it in due course by the mail, but we can email it to you if it would help you in any way.
Yes, I would. I would appreciate that.
If I could get an email address, sir.
Yes, email address will be my last name, Harris, Harris, the numerals 1009 at yahoo.com.
All right, I will make sure a copy of that filed order is emailed to you. It will come from me, Mitchell Freehoff, at Fulton County.
Thank you, Mr. Freehoff. I appreciate you. Yeah.
Thank you, Mr. Harris. Again, I'm sorry to always have to be the bearer of bad news, but I thank you for your understanding, and I wish you the best of luck going forward.
You too. Thank you.